Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about data security. Cases that should have gone to the Supreme Court of Canada, but didn't. Equifax was the subject of a data breach and hack, and ultimately the court determined that Equifax had maintained its databases in a way that was reckless as to people's personal protection of their information. Equifax was subsequently sued, and one of the things that was alleged in the lawsuit was that they had committed the tort of intrusion upon seclusion, essentially entering into somebody's private personal spaces. Because of the work that Equifax did in determining people's credit ratings, they had a lot of private personal information about individuals. And by storing, it was argued, the data recklessly in a way that made it very vulnerable to a hack and to an attack and to being stolen by unlawful actors, and by knowing as well as they did that they were vulnerable to these specific types of attacks, Equifax was arguably liable for the intrusion upon seclusion, even though that intrusion was done by a third-party actor because of their recklessness that allowed it to happen. And the court had to determine in the case whether or not it was plain and obvious that this tort could or could not apply to Equifax. And this is a very important question that the Supreme Court of Canada should have taken the opportunity to get involved in. The Supreme Court of Canada has the opportunity to hear all sorts of interesting issues that are on the cutting edge of where litigation is going, to provide guidance to courts that are determining issues that are going to come before them in many more cases in the future. When it comes to data privacy, the obligations of private companies to hold people's data and protect it, and to security on the internet when it comes to that data, the Supreme Court of Canada has never heard a case that's dealt with this and has never rendered decisions addressing this. This was the first opportunity the Supreme Court of Canada could have had to really get into what torts specifically apply to private companies that recklessly hold people's data and make it liable to be accessed in the event of a breach. And the Supreme Court of Canada really could have narrowed down the classes of torts by identifying which torts may be applicable or which torts are applicable to the circumstances, which would make litigation in this area, which is anticipated to be a massive growing area in the future, would have made litigation in this area a lot more straightforward, rather than having courts have to determine at the individual trial level whether specific torts apply and opening up every judgment to the possibility of an appeal, making every case have that lack of an air of finality. If the Supreme Court of Canada just took this opportunity to say, these are the torts that can apply until it is proven otherwise, we are going to say that these are the ones that apply in these circumstances, or even to create a new tort with respect to these issues, they could have avoided a lot of expense and time in the lower court systems across this country and created much more certainty for the law in the future going forward for everybody who is attempting to litigate these issues. It's unfortunate that the Supreme Court of Canada didn't recognize the significance of this to the legal system as a whole when it denied leave to appeal the case. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.